Good afternoon, everybody, and I just want to take a moment to thank everybody for being here today for this panel. We're lucky to have so many distinguished Republican attorneys general joining us, and we have several rookies to the panel, so I just want to acknowledge that. James Utmeyer from Florida, Liz Merle from Louisiana, Catherine Hanaway from Missouri, and Tim Griffin from Arkansas are all rookies to the panel. So it's great that we're getting, new faces. It's not always the same people. Although we welcome having people like Austin back every year.
I was just going to say, are we hazing the rookies?
That's entirely possible. Depends on their answers. Well, thanks everybody again for being here. I want to just sort of start and note that in October of 2025 was the 20th anniversary of the Protection of Lawful Commerce and Arms Act. The federal statute, bipartisan, is critical to protecting the industry from lawfare. Just this past June, the Supreme Court unanimously ruled in Smith & Wesson versus Mexico that Mexico's lawsuit against the industry in federal court in Boston was barred by the Protection of Lawful Commerce and Arms Act. In another product liability case, the Pennsylvania Supreme Court, not exactly a friendly state for businesses, very pro-plaintiff bench, ruled unanimously that the product liability lawsuit was barred by the Protection of Lawful Commerce and Arms Act, and the Supreme Court recently denied cert. Both of those cases involved a gentleman by the name of John Lowy from the Brady Center, who is now involved in a lawsuit against 5 retailers in Arizona representing the government of Mexico. But in many of these cases, Raga, you all were very kind enough to file important amicus briefs, and Austin often led those efforts. What we have seen since 2021, however, is an effort led by Everytown to adopt these statutes, reasonable control statutes, which are designed to gut the PLCAA by blowing a hole in the predicate exception and, everything. They just take all of the same lawsuits and theories, public nuisance, to bring those cases all over again against the industry, and we're starting to see that. You don't even, under these statutes, require a knowing violation. It's just if your conduct's not reasonable under the circumstances. So we're seeing these laws be used and enforced against Glock in a number of cases in New Jersey, in Maryland, in Chicago, Minnesota, Seattle. And we're seeing actions filed against small retailers, because the AG in New Jersey, for example, didn't like how they legally sold firearms and sued them because they weren't doing what he wanted, even though there was no regulation or law that required it. So that's a long sort of lead-in to kind of the question, which is the Protection of Lawful Commerce and Arms Act safe? Is it the law of the land? Or are we seeing now a new wave of litigation under these reasonable control statutes to bring the very claims that the PLCA is intended to bar? And is it a new tidal wave of litigation coming our way? Austin, you're right here, so I'll go to you.
I'll hit the first curveball. No, the Supreme Court has made it very clear the Protection of Lawful Commerce and Arms Act is the law of the land. We got a 9-0 decision in the Smith & Wesson versus Mexico versus Smith & Wesson et al. That was a fantastic decision. But you're right. What we're starting to see now is Everytown, Brady, Giffords, all those organizations are pivoting, and they're trying to come at it from the state angle. At the end of the day, I think they know what the answer is, Larry. I mean, we're going to end up back at the U.S. Supreme Court. They're going to get slapped down. But look, I think this is coordinated lawfare. This is aimed at this industry. This is aimed at making everybody have to pay lawyer fees and keep bleeding from 1,000 cuts. I mean, I think that's the game plan here. But I mean, you're going to keep seeing the Republican Attorney General Association and the people on the stage and our other colleagues who aren't here. We're going to keep fighting this fight. We're going to keep punching punching back on this?
Well, in one of the first cases challenging the reasonable controls, NSSF and a number of industry members sued in federal court in New York to challenge the first of these, the New York's reasonable control law. We lost in the district court. I think not unsurprisingly, we lost in the Second Circuit. They denied en banc. So we will be filing in mid-February a cert petition with the Supreme Court, and we would welcome support from you all.
You got
the
it.
Supreme Court.
We're teed up. We're ready.
Great, fantastic.
Austin Knutson from Montana, by the way. Hi.
Oh, I'm sorry. Everyone knows you. You've been here all the time. So that's fantastic. It's really important. And again, you guys in Raga have done phenomenal work in filing amicus briefs, across the board. The question I would have, and anyone can jump in on this, is, what can be done by Republican AGs to counter this coordinated lawfare campaign beyond just like filing amicus briefs? Is there things you think you could do to challenge what's going on with this coordinated lawfare? And it is absolutely coordinated between the three gun control groups, the Democrat AGs, and the big law firms that are part of the Firearms Accountability Coalition Task Force. Chris or Brenna, whoever.
Yeah, Chris Kobach, Kansas. Depending on the posture of the case, we can intervene if there's something that injures the state, qua state, as a state. We can always do, and of course we go on the offensive if there's something we can attack that we have a state law basis or some other basis to. I'm always looking for opportunities to intervene or to come in as a party, because that's always a stronger posture than being in as an amicus. But frankly, they know we're out there, and the blue states they know we will jump in as soon as we can. So they're crafting these lawsuits in a way that doesn't give us an easy entry in most situations. But rest assured, there's people on the stage who will happily, lead. Basically, one state has to take up the working oar and say, "All right, everybody, pile in the boat, let's go," and we'll definitely do it.
I think I was just going to point out, I think it's important to emphasize that many things can be true at the same time. The law can be settled, and we can also see an uptick in aggressive filings by the left. And here's the thing, this is not all about law. This is about messaging. This is about the broader political environment. And if you just narrowly view it as the law, you're going to miss half of the battle. And so, yes, the law is generally settled. Yes, we're going to see more and more of the same as if it's not settled, because that's what you would expect them to do. And no, it's not going to discourage anything, because this is not just about winning in court.
So are there opportunities to flip the script, to apply the same tactics against them? So for example, we hear all the time in litigation, the industry's advertising is deceptive, it's deceitful, et cetera, it's misleading. All of these groups fundraise nationally. They're sending emails into your states making false claims about the industry, about the Second Amendment, and your rights. Are there opportunities for you to use your state's Unfair Trade Deceptive Practices Acts, or even state Good afternoon, everybody, and I just want to take a moment to thank everybody for being here today for this panel. We're lucky to have so many distinguished Republican attorneys general joining us, and we have several rookies to the panel, so I just want to acknowledge that. James Utmeyer from Florida, Liz Merle from Louisiana, Catherine Henaway from Missouri, and Tim Griffin from Arkansas are all rookies to the panel. So it's great that we're getting new faces, it's not always the same people.
we-
Although we welcome having people like Austin back every year.
I was just going to say, are we hazing the rookies?
That's entirely possible. Depends on their answers. Well, thanks everybody again for being here. I want to just sort of start and note that in October of 2025 was the 20th anniversary of the Protection of Lawful Commerce and Arms Act, the federal statute, bipartisan. It's critical to protecting the industry from lawfare. Just this past June, the Supreme Court unanimously ruled in Smith & Wesson versus Mexico that Mexico's lawsuit against the industry in federal court in Boston was barred by the Protection of Lawful Commerce and Arms Act. In another product liability case, the Pennsylvania Supreme Court, not exactly a friendly state for businesses, very pro-plaintiff bench, ruled unanimously that the product liability lawsuit was barred by the Protection of Lawful Commerce and Arms Act, and the Supreme Court recently denied cert. Both of those cases involved a gentleman by the name of John Lowy from the Brady Center, who is now involved in a lawsuit against 5 retailers in Arizona representing the government of Mexico. But in many of these cases, Raga, you all were very kind enough to file important amicus briefs, and Austin often led those efforts. What we have seen since 2021, however, is an effort led by Everytown to adopt these statutes, reasonable control statutes, which are designed to gut the PLCAA by blowing a hole in the predicate exception and everything. They just take all of the same lawsuits and theories, public nuisance, to bring those cases all over again against the industry, and we're starting to see that. You don't even, under these statutes, require a knowing violation. It's just if your conduct's not reasonable under the circumstances. So we're seeing these laws be used and enforced against Glock in a number of cases in New Jersey, in Maryland, in Chicago, Minnesota, Seattle. And we're seeing actions filed against small retailers, because the AG in New Jersey, for example, didn't like how they legally sold firearms and sued them because they weren't doing what he wanted, even though there was no regulation or law that required it. So that's a long sort of lead into kind of the question, which is the Protection of Lawful Commerce and Arms Act safe? Is it the law of the land? Or are we seeing now a new wave of litigation under these reasonable control statutes to bring the very claims that the PLCA is intended to bar? And is it a new tidal wave of litigation coming our way? Austin, you're right here, so I'll go to you.
I'll hit the first curveball. No, the Supreme Court has made it very clear that Protection of Lawful Commerce and Arms Act is the law of the land. We got a 9-0 decision in the Smith & Wesson versus Mexico versus Smith & Wesson et al. That was a fantastic decision. But you're right. What we're starting to see now is Everytown, Brady, Giffords, all those organizations are pivoting, and they're trying to come at it from the state angle. At the end of the day, I think they know what the answer is, Larry. I mean, we're going to end up back at the U.S. Supreme Court. They're going to get slapped down. But look, I think this is coordinated lawfare. This is aimed at this industry. This is aimed at making everybody have to pay lawyer fees and keep bleeding from 1,000 cuts. I mean, I think that's the game plan here. But I mean, you're going to keep seeing the Republican Attorney General Association and the people on the stage and our other colleagues who aren't here. We're going to keep fighting this fight. We're going to keep punching back on this.
Well, in one of the first cases challenging the reasonable controls, NSSF and a number of industry members sued in federal court in New York to challenge the first of these, the New York's reasonable control law. We lost in the district court. I think not unsurprisingly, we lost in the Second Circuit. They denied en banc. So we will be filing in mid-February a cert petition with the Supreme Court, and we would welcome support from you all.
You got
the
it.
Supreme Court.
We're teed up. We're ready.
Great, fantastic.
Austin Knutson from Montana, by the way. Hi.
Oh, I'm sorry. Everyone knows you. You've been here all the time. So that's fantastic. It's really important. And again, you guys in Raga have done phenomenal work in filing amicus briefs, across the board. The question I would have, and anyone can jump in on this, is, what can be done by Republican AGs to counter this coordinated lawfare campaign beyond just like filing amicus briefs? Is there things you think you could do to challenge what's going on with this coordinated lawfare? And it is absolutely coordinated between the three gun control groups, the Democrat AGs, and the big law firms that are part of the Firearms Accountability Coalition Task Force. Chris or Brenna, whoever.
Yeah, Chris Kobach, Kansas. Depending on the posture of the case, we can intervene if there's something that injures the state, qua state, as a state. We can always do, and of course we go on the offensive if there's something we can attack that we have a state law basis or some other basis to. I'm always looking for opportunities to intervene or to come in as a party, because that's always a stronger posture than being in as an amicus. But frankly, they know we're out there, and the blue states they know we will jump in as soon as we can. So they're crafting these lawsuits in a way that doesn't give us an easy entry in most situations. But rest assured, there's people on the stage who will happily, lead. Basically, one state has to take up the working oar and say, "All right, everybody, pile in the boat, let's go," and we'll definitely do it.
I think I was just going to point out, I think it's important to emphasize that many things can be true at the same time. The law can be settled, and we can also see an uptick in aggressive filings by the left. And here's the thing, this is not all about law. This is about messaging. This is about the broader political environment. And if you just narrowly view it as the law, you're going to miss half of the battle. And so, yes, the law is generally settled. Yes, we're going to see more and more of the same as if it's not settled, because that's what you would expect them to do. And no, it's not going to discourage anything, because this is not just about winning in court.
So are there opportunities to flip the script, to apply the same tactics against them? So for example, we hear all the time in litigation, the industry's advertising is deceptive, it's deceitful, et cetera, it's misleading. All of these groups fundraise nationally. They're sending emails into your states making false claims about the industry, about the Second Amendment, and your rights. Are there opportunities for you to use your state's Unfair Trade Deceptive Practices Acts, or even state conspiracy laws, going after this evil cabal between these firms and these gun control groups, and again, at times, Democrat Attorney General?
Yeah, in Missouri, our Missouri Merchandising Practices Act is the broadest statute that we have to combat any of these kinds of false statements, and it also gives us the ability to do a lot of investigation. So to the extent that those messages are getting pumped into the state, we'd have a sort of a broad ability to go after them, and certainly something we would do.
Yeah, because we do see these claims against industry members, and like lawsuits against, for example, Smith & Wesson in California. It was all about their advertising. The Seminole case in Connecticut against Bushmaster, the Soto case, was an abuse of the state CUPTA, the baby FTC that the Connecticut Supreme Court allowed to be used, and it was all based on, Remington's advertising. So I would encourage you to take a look at that, because they are sending emails into all, every state. It's not, it's national, fundraising that they do. Or whether there are opportunities, whether they're in compliance with state, registration requirements for fundraising, or are they dotting their I's and crossing their T's?
Well, and I would also say, depending on your state, like Montana, for instance, the Attorney General's office has pretty broad investigative authority over nonprofits. And if they're engaged in fundraising efforts in Montana, and obviously it's going to be different from state to state, depending on what authority the AG has, but that's absolutely a stick that I have in Montana.
Yeah. I'd welcome any of you all to comment on the topic.
You know, we've used the authority of the state to prohibit discriminating against the gun industry. So we don't let people bid for our bond business in Louisiana. They can't be underwriters. They can't, they can't participate in our entire bond process if they are discriminating against oil and gas industry or the gun industry. So you can use the economic power of the state as well. And I think that sends an important message, and our legislature and certainly our governor and I have been very supportive of that requirement, because they want to, that's a lot of money. If all the Republican states were able to say, like, you can't participate in issuing municipal bonds in our state, you can't do any of that business here if you're going to discriminate against the gun industry, it sends a pretty powerful message. And most of them at this point, the banks who were debanking people for selling to, say, someone who's under the age of 21. Well, that's legal in Louisiana. So we said you can't discriminate against people who could legally buy or legally able to buy those guns in our state. I think everybody should do that. And the banks have pivoted some, but I also think that's partly because the Trump administration came in and withdrew some of that movement that had been backed by the Biden administration to use financing mechanisms to undercut the industry.
Yeah, I mean, we definitely saw that under the Obama administration, so-called Operation Choke Point. That was stopped. And the FDIC and DOJ admitted that they were engaged in that illegal conduct. And then it just got privatized by the banks, and we saw the same problems. And I would agree, the executive order from the president and his using the bully pulpit, calling out Bank of America, calling out JP Morgan. So we've seen a shift in the big banks. And we have been chasing around getting the FIND Act, the Firearms Industry Non-Discrimination Act, passed, and it has worked. And James, in particular, I have talked to banks, and I've talked to the OCC, and Florida's FIND Act version has been the most impactful in getting the banks to change their policies. I know for a fact Bank of America changed their policy because of that. JP Morgan Chase, we met with them recently. They said that they're aware of the FIND Acts, but they're most concerned about Florida. So use that, go after them. Block.
Yeah, we like to be aggressive, and these are all great ideas that we'd be all for. But we also could be working with our legislatures on the defensive approach to create new legislation that protects industry in Florida. We've spent several years heightening the burdens facing these abusive trial firms, ensuring there's not incentives for frivolous litigation, one-way attorney's fees, things like that. So we'll pursue it from an offensive litigation approach, intervening in cases, but also trying to create some safe havens to protect industry in the state.
To that point, I would just say a lot of people think of AGs and litigation, but really where I've seen AGs, particularly in red states where you've got friendly governors and or legislatures, and I know my governor is awesome and was on this stage a little bit ago, but one of the most effective ways we can help is to, when the legislature's not in session, we have time to make a list, be thoughtful, work with them on this legislation, and we can help bring a coherence to a package on things like this, because we're seeing all the different aspects. And the minute that the session starts, ours is every other year for a general session, then that package, which we passed the Second Amendment Privacy Act, for example, last session, which prohibits financial institutions from discriminating. But that can be one of 10. And one on their own is not sufficient, but you can really make an impact if you go in with a legislative package like that. And I think AGs are some of the best leaders for that sort of in-the-weeds detail because of what we see every day.
Yeah, no doubt about it. Brenna, I mean, I know we pursue litigation or legislation in Iowa to address many of these issues. And
Yes.
You've been a great champion of the industry.
We have, and we've been really successful, and with you working those issues too in your team, There are some great things we can do at the legislative level. We got rid of the prohibition on under 21 ownership of guns. The legislature talked to us about that. So there is a role for an AG's, an Attorney General's office behind the scenes, working with legislators, making sure that the law they're going to pass, that it's defensible in court, that it's going to work the way that we all want it to work, that it's enforceable. That kind of partnership is so valuable and so impactful. And now I think really is the time for us to lock in some wins and to put some firewalls in, make sure that we are battening down the hatches to protect the Second Amendment. And it's important to do that when times are good, as they are with the federal government, because we certainly hope and pray that will always be the case, but history tells us it likely isn't. I want to hit one more thing that I think is really important when you have these groups out there just really targeting the Second Amendment and all the companies and good people associated with it. And you have attorneys general, I would say, on the other side who are helping them and who are part of what they're doing. I think one basic thing we can do, and I'm thankful to be sitting here today because I just got elected in 2022. This is my 4th year as Attorney General. And when I ran against a Democrat incumbent who'd been there 40 years, since the 70s, and he was not a supporter of the Second Amendment at all, right?
Not at
and
all.
so it just does my heart a lot of good to see the involvement that I can have in Iowa's Attorney General fighting for the Second Amendment, but also with all of these great colleagues who really do a lot. And we work together doing that. But that was what was necessary in our state to make that difference. And so we shouldn't be afraid to take that on either, because the issue of Second Amendment constitutional freedoms is something that many Americans care about, and it's one that is an issue of great importance to folks as they're headed to the polls.
So, General McCuskey from West Virginia, you've been a tremendous champion. West Virginia, in many respects, has been a leader on these issues with creating state protection, liability protections. You want to speak to what's going on in your state to protect the industry?
Yeah, I think just to sort of start off with, there's a reason why there aren't 8 Congress people sitting up here. And the reason is that when you're in the world of politics that we're in now, it's really, really hard to get anything done in Washington. And all of the large-scale conservative change that you've seen over the last 20 or so years has really been taken up by the group of people that are on the stage. And whether it's the First Amendment, the Second Amendment, the Fourth Amendment, you name it, we are all leading the charge to make sure that the Constitution means what it says and is interpreted that way. And it's really because Congress has abdicated the duty into the states. I think one of the real big tools that we have as AGs is that we can sue other states, right? And we sue other states all the time, right? We have a lawsuit against New York that all of us are on in the energy space, right? But it's actually easier in the Second Amendment because of its enshrinement in the actual Constitution. So when we are standing up for the constitutional rights of West Virginians or Iowans or Kansans or Floridians or who you name it, right, we can reach into New York or California and say, look, this is an infringement upon the rights of people of West Virginia. We can't go to California, right? Because your laws don't allow us to have the same Second Amendment rights that we have at home. And I really think that's going to be kind of the next great frontier, is it's going to be Iowa versus California, or Kansas versus New York, or West Virginia versus Connecticut, or Missouri versus Rhode Island, or whatever, name the state. And that's how you're going to start to pick off the states that are doing the real harm to their own citizens, right? I mean, you would think that there's nobody in Connecticut that owns a gun, right? By the way that their legislature and their attorney general and their governor is, but
They're trying to make that the case.
yeah, but I mean, I don't know the answer to this question, but I'd say probably 40–50% of people in Connecticut probably have a firearm, right? And so there are folks there that need represented by an attorney general. They just didn't happen to have the one in their own state that's able to do it. And so we are kind of the group of people in this country that are really standing up for all of these wildly important constitutional issues.
You raise an interesting point, because one of the claims that NSSF has been raising in our challenges to these reasonable control statutes is that, among other things, they violate the Dormant Commerce Clause.
Correct.
Because they are directly regulating out-of-state lawful commerce under federal law, and we had plaintiffs in the New York case purposely from like a dealer in Montana. We had a distributor from Louisiana, and because the way the statute was written, they could sell a gun a distributor in Louisiana could sell a gun to a retailer in Montana, and if that gun, through no actions of anybody in the industry, ends up in New York and being misused in a crime, individuals, not just the state, could sue anybody in the chain of commerce. And we read this is a dormant commerce clause violation. We actually got an injunction in New Jersey, but we got the Third Circuit threw us out on standing, which was frustrating. And we've gotten a preliminary injunction in California on a portion of their law on the dormant commerce clause. But I think it's a very interesting angle, because they are trying to suppress lawful commerce that makes the right possible all across the country, not just in their state.
Yeah, and it goes the other way too, obviously, right? I mean, the people that want to take your guns away are equally aware of how important, we are and the Dem AGs are, and their law firms just make money off of filing cases. Right? They don't care what the verdict is. They're just trying to muck everything up. And so, and you see this across the gamut of all the conservative issues, right? I mean, the Greenpeace is the exact same thing, essentially, as Lambda Legal, and it's the same thing as Everytown or whatever. They have this group of do-gooder lawyers that there's no downside for them to file these cases, right? And that's, I think what James was talking about earlier. I mean, that's really going to be a big deal, is to create a downside for them to file these cases.
Absolutely.
The great advantage that JB's approach has is when one state sues another, the U.S. Supreme Court takes that case directly. So we don't have to spend all that time fighting through the district court, the Court of Appeals, getting granted cert. So I think it's a great strategy.
Yeah,
They're supposed to take it. They don't
They're
always.
supposed to.
The Constitution
Right.
says they're supposed to.
Says shall.
If they
Still working on that.
That's
Yeah.
right.
Yeah, that pesky little thing, the Constitution.
Two that want to take it.
What
Need a
does
couple
is
of more
mean?
votes.
Yeah.
Yeah, that's funny. So let's turn to another important issue, particularly for the industry. I mean, there's lots of litigation going on across the country on Second Amendment issues, concealed carry, the vampire rule, et cetera. But for the industry, one of the core issues, hardware bans on modern sporting rifles, on magazines. There are many, many cases. The Supreme Court has not granted cert on any of these cases. Justice Kavanaugh last term, talked about how we're not going to grant cert, but the next term or two, we really got to kind of take one of these cases. Justice Thomas and others, have filed dissents and denials of cert. And yet there are many, many cases sitting there before the court with cert petitions. Duncan, for example, they keep kicking the can down the road. Why do you think that SCOTUS has not granted cert in any of these hardware cases? Because I don't know why, so.
Well, they need to.
For sure,
They
yeah,
need
it's
to.
desperately,
Yeah.
right.
Yeah, especially because those types of restrictions in states are basically a way to outlaw people's Second Amendment rights by restricting a magazine size in the way that they do. My first inclination of that, my husband's from New York and he's a veteran, and when he lived in New York, that type of regulation was being talked about and then put into place, but he was not allowed to have a firearm, right?
Yeah.
Unless a judge let him do it, which apparently they never let people do that. So it's obviously a way to make sure that people can't exercise Second Amendment rights. I think that's why it's getting so much attention from the court where it's getting mentioned. We all wish they would take it up. It's something that we're looking for and we'd like to see. It's just sometimes that court, because they take so few cases, it seems to move very slowly. And we are seeing them taking a number of other cases, like the Hawaii case. I mean, that was I'm very encouraged there by what's happened so far and the questions asked. So I think that one has to be on their shopping list where they're looking for the right type of case to take up and to make it very clear that a state can't use something like limiting magazine capacity as a way to basically outlaw certain types of firearms in their state or make it very hard for people to own or possess them legally.
General Kobach.
Yeah, I think we need to put it in historical perspective, right? Because before the DC gun ban case, there had been the last case prior to that was the 1930s, so there was a 60 to 70 year gap where they didn't take a single Second Amendment case. And so now we're in this much better situation where the U.S. Supreme Court is taking a lot of cases. And then on top of all of that, we got the Bruin decision a couple years ago, which elevates the Second Amendment to not only on par with the other amendments, but in many ways gives the Second Amendment a superior protection in the Constitution. And so I'm just tickled the fact that the court's been taking roughly a case a year on the Second Amendment, which, so I have no, I mean, I'm someone who has many times had cert denied where the Supreme Court didn't take a case where I thought they had to take that case. And so, you know, they routinely make mistakes in which cases they don't take. But I do think on the Second Amendment, my impression is that the conservative majority that we have is being very careful about which ones to take, because the Bruin standard is now being, you're seeing the second and third and fourth application of it. And they want to create, I think, a case law, a body of case law that's going to stand, you know, last for many, many decades, hopefully forever. And I think they're picking the cases carefully based on, you know, they don't want bad facts to create bad law. So I think they will eventually get there, but I'm not complaining about it right now, because I think they've taken some really good cases. And the Hawaii case that Brenna mentioned is, you know, I think we're going to get a win there, and it's going to be awesome.
But I would say to that point, like you have to pay attention to what the composition is of our courts of appeal, our federal courts of appeal. We're like, every case is not going to get sorted out at the United States Supreme Court. It just won't. Those are the numbers. I mean, just purely based on the numbers, they're not going to be able to do that. But so we need to make sure we have the right people on the bench, and that we're putting the right people to be, you know, elevated to that bench, because that matters, and that's where this is predominantly going to be decided. And for a lot of people, is going to be, and for a long time, I mean, you may, you know, every 5 years, if you're lucky, you might see a gun case at the United States Supreme Court, and that would be unusual, you know, when you look at what the history is.
Which is another reason why this group is so important, because so many of the judges come out of our offices. I mean, you've had
true.
That's right.
two, I think, this year, right, Liz?
Yeah, well, we have quite a few.
Yeah.
I mean, our offices do work at creating people who are well suited to take the bench, but I mean, that's because we're doing so much work through all of our Solicitor General's offices. Yep. I was the Solicitor General before I was Attorney General, and you know, that's where most of that work gets done for the Attorney Generals, and just an exceptionally bright group of people who are, you know, stalwart defenders of freedom. So it's a privilege to work with them. I loved being a Solicitor General, and I love working with them. They're just so smart and great to work with.
Just for our audience that might not know, I mean, we're throwing these terms around. Our Solicitor General, they're basically our top federal lawyers that work for all of us. Each one of us has got a Solicitor General's office. That generally, that person and their staff are the ones who are doing all our appellate work in the Ninth Circuit, in the Fourth Circuit, or in some instances even going to the U.S. Supreme Court. You have to understand that's a very, very small club. These are the nerdiest of the nerd lawyers, but they're amazing.
But there are nerds.
There are nerds. There are nerds. They're amazing nerds, and these are the nerds that literally are the ones that get vetted and picked to be federal judges at some point. Like, that is the goal of this entire small group of people. That's where they're all aspiring to be someday. So, to be in a position to work with those people, to select those people, to get them these cases, I mean, this is tryouts for the federal bench. Ideally a federal bench, hopefully even a circuit court of appeals someday, maybe even the U.S. Supreme Court. So that's why we're talking about this, and that's why these cases matter so much.
Yeah,
We got to try to explain what a woman was last week.
It was great.
I'm not sure I needed a Harvard.
I don't think we really got an answer.
It didn't feel like I needed a Harvard-educated lawyer to do that, but
You did
apparently
not need
we
a
did.
law
Yeah,
nerd
that's
for
right.
that one.
Yeah.
the SG shops is relatively new. For example, in Arkansas, I think our SG shop started about 10 years ago. So the last two SG Solicitor Generals in Arkansas, one is a federal judge and one is a justice on the Arkansas Supreme Court. And
your new one came from me.
and the new one I stole from her. You know, we're just fortunate Liz didn't go straight to the bench.
For an undisclosed sum of cash and a draft pick.
Later to be
She's
named
awesome.
later.
She's
Later to be
awesome.
named later.
I do want to reiterate the importance of what Brenna said a little bit ago about the ballot box. And in Missouri, when, you know, time after time on issue after issue, liberals have not been able to have their way. They've gone to the initiative petition route to legalize marijuana, to legalize abortion, to legalize gaming, and I think at some point they're going to come after Second Amendment rights at the ballot box. So this year, we have a measure on the ballot in Missouri to make it more difficult to amend our Constitution by the initiative petition process. It's critically important that people who care about Second Amendment show up and vote for things like that, even though it's maybe 3 moves down the chessboard.
Yeah, well, NSSF runs a very aggressive voter registration, education, and mobilization campaign every 2 years from
Thank
federal
you.
elections, gun votes. So it's absolutely critically important that gun owners get registered and they vote, they show up, right? I mean, like every time, like, and not just, federal elections, state elections, your city council, your, county commission, right? At every single level, you need to be engaged. It's the only way to protect the right in the long run. So I really appreciate it. So another question, and it's kind of related, but let's assume, and perhaps it's the Third Circuit case that was argued en banc recently, and the challenge to New Jersey's so-called assault weapons ban and magazine capacity restriction. The expectation is that the Third Circuit will rule favorably, and ironically, because of the states it covers, the Third Circuit might be the most conservative court right now of the appellate courts, Court of Appeals. Let's assume they.
It's a stretch, but go ahead.
Well, it's tipped, right? It's
Much better, much better.
yes.
Yes, sir.
Let's assume they take that case because that would have a undeniable circuit split on the issue, which is, I think, one of the reasons why they haven't taken a case yet. But does anybody have any concerns about how this court, as currently comprised, would decide a hardware case when they take it?
I don't. I think under Bruin, they're going to go the right way. It's hard. The other side hasn't been able to come up with historical analogs.
Because they don't
That makes
exist.
sense.
They don't.
Right.
They probably won't be able to define assault weapon either, would be my guess.
Yeah.
Well, they've always
Much
struggled.
like the word woman, I don't think
Yeah.
they have an accurate.
They don't, as we know. They have no idea. And there's another case in the Seventh Circuit that NSSF is a party to, where we actually won in the Southern District of Illinois on Illinois' so-called assault weapons ban that banned so much more than so-called, AR-15s, et cetera. I mean, and magazine capacity. So we're waiting for that case as well. But I think based on the oral argument, and Harmeet Dillon, the Assistant Attorney General, argued in the Seventh Circuit as well. I think we have a good chance of winning that, but of course it'll go en banc, and then it's anyone's guess. But so no one thinks there's a chance that the Supreme Court comes out on the wrong way on an assault weapons.
Oh, I'd say there's a chance. I wouldn't take it for
Yeah.
granted. I mean, it's it's not a given. I mean, every fight there is a battle, and I think we've seen them. I think we've seen the majority of the court stay pretty, show a lot of fidelity to the Second Amendment, but. Like we've said up here before, these cases are very carefully selected. Like they're not accidental. The people who bring the laws that we're having to challenge, the cases and the plaintiffs, they are carefully selected to try and basically build a case and put a case in front of the United States Supreme Court that they think they can win, so that they can, incrementally carve back some of the power that they feel like they lost with Bruin. So you asked in the very beginning, are we safe? No, we're not. I mean, we're never going to be. I think in terms of the continued incursions and attempts to carve back against and draw more nuanced distinctions to give more room for them to roam.
Yeah, no doubt. So let's turn to another issue that's been sort of hot in litigation lately, and that's laws enacted with age restrictions, that your 18 to 20-year-old can't purchase any firearm. I mean, we know what the law is, federal law is, but we've seen these enacted in a couple of states, and Florida obviously has been on the front line of that, as has, General McCuskey, you've led the effort, in the McCoy brief. James, you want to talk a little bit about, your decision not to defend what you viewed as an unconstitutional law?
Sure, yeah. Well, when I took office, it was probably a month later, the 11th Circuit ruled to uphold Florida's law heightening the age restriction to purchase firearms to 21. At that point, you know, it's going to get appealed to the Supreme Court, and I've got a sign to defend that law, which I believe unconstitutional. So I made the decision that, you know, attorneys general, you know, rarely make to not defend a state law. You know, my oath is to uphold and defend the state law, but my primary oath is to uphold and defend the Constitution. And if you look at the interpretation at the time of the founding, if you were at the age of majority, you weren't just allowed to purchase a firearm. Many times you were expected or required to be able to serve in the militia. So I ruffled a lot of feathers with our Republican leaders, despite being a Republican state for, you know, the better part of 20 years. Before the DeSantis administration, you know, in the wake of a, you know, shooting, they had a knee-jerk reaction and put all these restrictions in place. And, you know, we were on a list of one of 4 or 5 states with California, Illinois, New York, you know, the list you do not want to be on, where, you know, you had to get a license for concealed. There was 0 open carry. We got tons of red flag laws, this heightened age restriction. So we've come a long way. Not only am I not defending the law, but we've actually sided with the NRA, and I'm filing briefs against the state in the Supreme Court, which is a little bit interesting procedurally, but I feel very good about the arguments. And now we see our state leaders coming around. Legislation's moving to repeal that heightened age restriction, and I feel pretty confident it's going to pass, which will be a good thing. And then we had a great ruling. One of our appellate courts recently announced our prohibition on open carry unconstitutional following Brune. Which was a great result. We sent out a statewide opinion interpreting that now as the law of the state in light of no other court ruling on the topic. And law enforcement, the prosecutors, local police, thankfully everybody's gotten in line and has agreed with me that they will not enforce a ban on open carry. So we've come a long way in just a few years. We still have some fights ahead of us, but Florida is actually now becoming the free state of Florida in spite of some weak Republicans that came before us.
General McCuskey, you've led on this issue as well, particularly in the McCoy case.
Yeah, I mean, I think an infringement on the Second Amendment anywhere is an infringement on it everywhere. And that's another one of these laws that doesn't have any reason. I mean, no one has ever made the case that 18-year-olds are incapable of owning a gun. Right, I mean, it's just an assumption that they can't, and so many laws get passed like that, right, where people just say, oh, well, if you're 18, you're not old enough to do this or whatever, and none of them involve a constitutionally enshrined right. And it's hard for me to imagine trying to keep an 18-year-old from talking, right? I mean, it's not like the First Amendment stops applying to you when you're a child, right? And so these ones are easy to me because the argument against them is hypothetical and irrational.
Yeah.
I'd encourage, you know, states to go even further. In Kansas, we allow 18 to 20-year-olds to conceal carry, and most states still do not. Most red states still do not. And we've also allowed concealed carry on our college campuses.
Yeah, we did that too.
And a few of us up here have that in our states. And you know, the Brady group and every town were like pulling their hair out, saying there's going to be warfare on our campuses. And we've had those laws in place for several years now, and everything's good.
They're a opposition to concealed carry, campus carry. It's always the blood in the streets.
Right.
And it never happens.
Every time.
Correct.
Right.
And yet that's their knee-jerk reaction and argument every single time. We're actually up from New Hampshire. We're seeing a debate in the legislature about constitutional or campus carry, and that's the immediate, like, it's just, I'm laughing reading it because it's like, I've seen this movie before. So it's, so I want to talk, General Griffin, we had an interesting conversation backstage, and it touches on some of the discussion earlier about, you know, the duty to defend or not defend, and General Othmeyer touched on it a little bit. Can you talk a little bit about our discussion and why it's important?
Yeah, so I think it's important, first of all, congratulate you, applaud what you're doing on that. I think it's important, whether it's First Amendment, Second Amendment, whatever it is, I think it's important to understand what your options are with the duty to defend. Every state can be different depending on whether there's a constitutional provision about the duty to defend. But in my state, before I took office, I knew of instances, particularly on campaign finance law, First Amendment, which is speech. I knew that there were some unconstitutional laws that my predecessor had that they were defending, her staff was defending. And I said to myself, well, I wouldn't do that. If I were, when I become AG, I'm not going to do stuff like that. In fact, I'm going to look for laws that I know are unconstitutional and try to find a way to get them killed and gone, because ultimately my oath is to the U.S. and state constitution. And if I know something's wrong, I got to take steps to deal with that. So when I got into office, I looked for a case where I could publicly say, I have no duty to defend. And I decided that there was no statutory duty, there's no constitutional duty, there was no ethical duty, if there was really no argument that could be made to defend a law. So I found one that was not related to the First Amendment, not related to the Second Amendment. It was a Dormant Commerce Clause case that had to do with how long you had to be a resident before you could sell liquor in Arkansas. It was a protective statute, right? And one had already been stricken that had a 2-year residency requirement. It had been stricken in Tennessee 7-2 by the U.S. Supreme Court. And I knew our 4-year requirement was unconstitutional, and my predecessor had been defending it. And I said, we're not defending it. Just admit it's unconstitutional, and it'll be taken off the books, and that'll be that. And that applies here. But it was really important for so many reasons for me to articulate publicly, and there was a big article in the paper because it was not something that had been done a lot before, for me to say, I'm not going to defend laws willy-nilly. And after that, I was able to go to the legislature, and it becomes part of the mix, right? When you say to legislators, this will be dead immediately because it will be challenged and I won't defend it, you have a tool that you didn't have before. And we've been able to use that to improve what they're writing to get to a point where we can defend it. And then we can weigh in and be for it. So I applaud what you're doing, because what you're doing is I think you've already indicated that now the legislature sees, right? When they can't count on you to just rubber stamp their bills, you have a new power. And it's a constitutional power that is that I think is to be lauded.
That's fantastic. So I want to just touch on another topic that we've seen a lot of litigation on, and it's an area that NSSF has been active on, and that's enacting waiting periods. In some states it had them in the past, California pre-Bruin, but we've seen a number, and this has been pushed by Giffords in every town, enacting state laws to require waiting periods, cooling off periods that apply even after you've passed the NICS background check. So you're already established that you're a law-abiding citizen. So, there's the case in New Mexico, there's a case in Vermont, there's a case in Maine that we've been supporting. We obtained a preliminary injunction against the Maine 72-hour waiting period, and it's been argued in the First Circuit. So I commend, Austin, your leadership in filing an amicus brief in that case, and we're hopeful we will prevail. But why do you think this is an important issue?
Well, it's unconstitutional. I mean, pretty axiomatic, right? There is no historical analog anywhere under Bruin, right? That's the standard now. Bruin says you get to bear arms, okay? And any restriction on that has to have some sort of historical analog. And the only one that the Supreme Court could point to really was polling places. Generally, it was very, very tight. There's just not a lot of historical analog, but there is zero historical analog for a cooling off period before you can buy a firearm. This does not exist. This is a legal fiction, but I think even more so, like it's a factual fiction. Mm-hmm. Bad guys aren't buying their guns at Joe's retail gun shop. Like they're just not. So that this idea that we're going to prevent crime by, if we can just make someone take a breath and not buy that firearm,
Yeah.
It's just complete fiction.
The other justification you hear of these laws, and we certainly heard it in the Maine case, is, well, it'll reduce suicides because of just have a cooling off period. And of course, there's absolutely no evidence that really supports that assertion whatsoever. And it's the argument you always hear, like, well, there could be a benefit, some social benefit, right? They're right back into interest balance weighing.
The left does not deal in logic or facts. They deal in emotion. Like it's just a fact. That's it.
So the 10th Circuit ruled in the New Mexico case, so we've been telling dealers, now that the mandate is issued, you can sell, even if you're not a named plaintiff, because I can't see how the New Mexico Attorney General could try to enforce the law based on the court's decision. But we've heard that New Mexico plans on seeking a cert petition for the Supreme Court, so I suspect we'll be knocking on your doors to file an amicus brief in that case as well. So as you know, and you've seen, we've got a lot of folks from the White House here, the White House counsel, the Deputy White House counsel, the Assistant Attorney General Dillon, et cetera, and obviously Todd Blanche, the Deputy Attorney General. And it's a breath of fresh air, under the Trump administration with the executive order.
And don't forget, the Attorney General is a former state Attorney General.
This is
as well,
true.
so.
Yes. James knows that very well. And now the former Attorney General of Florida is the senator. So I would just be interested in hearing your perspectives on the Trump administration 2.0, the executive order, and just the general change in philosophy on Second Amendment, and what you think that represents for the future of this country.
I can start. I mean, I can give one example of just how amazing the transition is and how much better it is, and I'll give one example where it might give us a little pause. The amazing one is right at the end of the Biden administration in 2023, Biden's ATF promulgated a new rule that redefined what it is to be engaged in the business of selling firearms, and broadened it so far that if I sell a shotgun that I'm not using to JB, and indicate a possibility that I might sell, I had two of them, I might sell one to Austin as well, I'm engaged in the business. I don't even have to sell them yet. I'm engaged in the business. They also took, which many of you may be familiar with, there's an exception for your personal collection. So when you're selling from your personal collection, you're not engaged in the business. They said any firearm that can be used for self-defense cannot be considered part of a personal collection. Now, last time I checked, every firearm that functions can be used for personal defense. Anyway, it was a crazy rule, and we sued, Texas sued, a bunch of these states up here on stage.
We all sued.
Yeah, joined in on the suits, in the two suits, the Texas and Kansas ones. And as soon as the Trump administration came in, they agreed to stay the enforcement of the new rule. And they said, we're going to rewrite the regulation, and they say that it'll be before January 31st. So within the next 10 days, we should hopefully see a new regulation. So that's a perfect example of them turning 180 degrees, fixing the unconstitutional problem. Let me give you one that's got me a little worried, though, and I hope there are some White House people listening at this point, and that is...
Sitting right over there.
Oh, okay, yeah, there he is, Todd. Okay, this is a perfect example that I won't ask Todd to respond. But so another area where we need something done quickly is the NFA's use of the taxing power to regulate suppressors and short-barreled rifles. As many of you know, everybody should know, the big beautiful bill removed the $200 tax, and the only reason Congress did that was to take away the one leg that regulation was standing on. In 1937, the U.S. Supreme Court ruled that the 1937, 39, whatever, in the late 1930s, the Supreme Court ruled, I believe it was a 37, that the NFA can only be justified as the exercise of the taxing power. Even said it cannot be construed as a commerce power, because Congress didn't say it was using commerce power. Congress said this is a tax and that's all it is. The big beautiful bill took away the tax, so therefore the whole thing no longer has any constitutional basis whatsoever. Unfortunately, the current administration, our friends, are still, through the ATF, still registering, regulating, putting these onerous burdens on firearms owners who are simply seeking to get something to protect their ears or something, a shorter version of a rifle or a shotgun. And it's still being enforced, and as a result, all of us are on a cert petition in the Eastern District of Missouri, where we are litigating against our friends in the Trump administration, Department of Justice. There's also a case in the Northern District of Texas, where several of us are parties against the U.S. Department of Justice on this very issue. And the Justice Department position is that, oh, by the way, there's another tax on the businesses, and maybe we can extend the reach of that tax and say that covers all the regulations we'd like to keep in place on suppressors. They're also, oh, and by the way, the Brady Group is lined up with the U.S. Department of Justice in these cases. I don't understand it. I've pressed the case, and the two answers I've gotten are, well, look at all the good things we did for you over here. And the other answer was, well, there might be some other laws that could be in jeopardy if the taxing power is no longer a basis for those regulations or laws. And my answer is, so? Then they're unconstitutional. So anyway, I love what the Trump Justice Department is doing, but on this particular issue, it just vexes me why they're not with us on this stage saying, hey, that's unconstitutional, we can't do that.
Anybody else want to follow on?
No, I mean, I'll just make the comment that the Biden administration ATF rule just is a really good example of how much power the federal government has to act through the administrative state. You know, we've been fighting that. You know, we launched lawsuit after lawsuit after lawsuit, either, you know, related to gun regulations or oil and gas regulations, because the government decided that it hated two industries. And it decided to take down those two industries. And it used and they were unapologetic about it. I mean, they came out in the first executive orders that Biden issued and said, you know, we don't like these industries, we think they're bad, and we're gonna use all of the power of the federal government to take down those industries. And I mean, honestly, I mean, I've seen a lot of administrations come and go, but I don't think I've quite seen one that was as quick and effective. Now, the Trump administration has been equally quick, and I mean, I'd say more quick and more effective in terms of taking a lot of regulations down. But they planned for this, the Biden administration did, and they planned and came in and very carefully started pushing a lot of administrative rules through, and it is time-consuming and it's just legally time-consuming to be able to get those things litigated, to take them down, to run them through the courts of appeal, and so they are effective. They are effective for a long time, and when they get the banks on their side, when they capture the financial underpinnings of an industry and start threatening them, and then they play ball because they decide that's a policy that they like, you know, it becomes very, very problematic. And so, you know, I think that we just have to we have to just be very, I think, diligent about guarding who our leaders are, because it makes a huge difference. And if you need any illustration of that, just look at the last 4 years.
Yeah, back to the point, elections matter, right?
So the one thing I would say is that the Trump administration, right at the very beginning, made a concerted effort to reach out to us on these sort of friendly cases. And my presumption is that's probably never happened before. I mean, I don't know that a White House has ever sort of intentionally mobilized the state attorney generals. But, you know, they sort of asked us for a list of like friendly cases that we could file against them that they would just say, you're right. And it is amazing how quickly you can get something done when the person that you're working with agrees with you.
Well, and certainly we've seen that tactic used by the left, and particularly in the environmental space, like on lead ammunition, the sue and settle. I mean, they were transparent about it under the Biden administration. I mean, they even called it sue and settle, and so that's an important tactic. I mean, it's perfectly appropriate to do that.
Well, here's what I would say is the Trump administration has been fantastic. Administrations change. And that's why it's so important that we pass things at state level like the fine law, because while the current administration has made those banks be more willing to loan, it could change like that with a new administration.
and
They
it
don't
will.
put those laws in
Will.
place.
It will.
Right.
Yeah, I mean, we're very pleased to see JP Morgan Chase, Citibank, Bank of America, et cetera, change their tune. But I have no doubt that, if there's a Democrat occupant in the White House, they're going to go right back to the same old, because they really believe it, right? I mean, that's in their DNA. They're only responding to pressure from the Trump administration, the executive order,
Right.
Adding co-sponsors to the federal legislation, the FIND Act. I mean, I met with the head of JP Morgan Chase Business Banking, and they admitted, they were responding to the pressure from the White House. They made reference to the lawsuit that's coming from the president against JP Morgan Chase, and they specifically mentioned, their concerns with the Florida FIND Act, which I would say for all of you, if you push that in your states with your legislatures, the FIND Act is the template. It's been very effective, and it made those banks change. So we're very pleased to that. We're pretty much out of time, so I want to thank you all for joining us again, and for our first timers. We hope you found it a good opportunity and a good use of your time. Thank you for everything that you do to protect freedom, liberty, the Second Amendment, and in particular, your support for our industry. It's very much appreciated. So
Well, and on behalf of Raga, I mean, thanks NSSF. I mean, NSSF is a fantastic partner for us. I mean, we communicate quite often. When there's things that pop up, having this relationship with the industry and with this group and with Larry, I mean, we can mobilize and we can move quickly, and that's really, really effective.
yeah, we really appreciate everything you do. It's so critical, and you're such an important ally, because we certainly, see what happens on the other side. The gun control groups working with the Democrat AGs that just want to destroy our industry and destroy the Second Amendment. So thank you very much. I really appreciate your time.
Thanks, folks.
Thank you, Brian.